Crimes against shareholders. This is for Module 3, Readings Part 1. Start with some key historical examples of investor fraud. One of the most famous, by Charles Ponzi, who ended up naming the Ponzi scheme. He parlayed just $150 into $9.6 million within 8 months, paying out some of the new investments to initial investors to generate the buzz that would keep the money flowing in until the whole house of cards collapsed. Ivan Kruger, who built a much more substantial firm globally in the 1930s, it ended up being a monopoly on match production worldwide, but racked up massive debt, equivalent of about $70 billion today, hid the losses, and collapsed in the Great Depression. Then you had somebody like Richard Whitney, one of the most respectable members of the establishment on the New York Stock Exchange, head of it, did the sort of petty ante stealing money from an estate in the 1930s, but became a symbol of white-collar crime, of those in positions of trust betraying that to enrich themselves. One study of 133 criminals involved in investment fraud found a few key things. One, most of the violators had some financial problem that they couldn't share with colleagues or family, had fear that if they shared it, they'd lose status. And they became aware that the problem could be secretly solved by violating that position of financial trust they were within. And they found they could adjust conception of themselves as trusted people. They could rationalize the behavior as only, quote, borrowing the money, or they felt they had been underpaid for work they had been doing. Often there was some degree of personal overspending that led to them justifying the illegal activity to get themselves out of the hole. Interestingly, many women seemed to violate the trust that they were given to help those around them. Note that as women gained status in business, they increased as a percentage of embezzlement arrests by 2010. Talking specifically about insider trading and what it means. Definition: trading that takes place when those privileged with confidential information about important events use the special advantage of the knowledge to reap profits or avoid losses on the stock market to the detriment of the typical investors who buy or sell their stock without the advantage of insider information. So the idea is not just that you benefit yourself with insider information, but because you take part of that profit or avoid part of the loss yourself, you're by definition passing some of that on to others who bought or sold at whatever higher or lower price that you knew and that the market adjusted and they were left holding the bag. But that simple argument around insider trading, there's a debate even amongst economists on overall, does insider trading hurt the economy, hurt the firms involved? The criticism of insider trading laws comes down to this. There's the argument that it's one form of compensation for corporate employees. You can hire them with the investors who are de facto hiring them. They pay them lower salaries, which benefits the shareholders, and those executives get some profit for themselves through their insider knowledge. There's the idea that it's an incentive for them to innovate, since it promises them big rewards if the stock increases and they know because of their own work that the innovation is going to lead to that result. There's the argument that insider trading laws are unclear and unfairly penalize people who come close to the line, although there is a focus in the law on fraudulent intent that can address that concern, since if you're playing near the line and you mean to go near the line, that's different from accidentally wandering over it. The other argument for insider trading is it gives insiders the incentive to reveal information to the public through their trading, where otherwise, if there's something bad about to happen with a firm, if you don't see the insider selling, you won't actually signal to the public that it's time for them to get out as well. But the argument for insider trading laws are also pretty clear. The problem is that those incentives created for executives, for corporate insiders, can make them go towards risky ventures, that they can take short-term personal gains, sell the stock if they know there's a loss coming, and they get out before the damage is done. It also encourages putting off public release of important corporate information, since the longer it's secret, the more the insiders can benefit if there are no insider trading laws. And there's a broader problem, probably the strongest argument made for insider regulation, which is if average investors think the stock market is rigged, that insiders are taking most of the profits and leaving them with losses, the public won't trust to put their money in the market in the first place, and the whole system will go into a bad cycle of decline. Here's some key facts about insider trading investigations. The Securities and Exchange Commission can only make civil lawsuits. If there's a criminal charge to be made, they have to pass it on to the Justice Department. This often creates some turf issues over taking political credit, and it can sometimes encourage the SEC to pursue more civil charges because that's where they get the maximum political credit. Most of those charged in insider trading are relatives or associates of an insider who tip them off. So while the actual employee may or may not trade themselves, but they often will pass the tips on to others, whether it's because they like the people or because they expect another favor in the future. This is the idea. It's often about building relationships. You can see this in many of the dynamics, that the exchange of insider information builds alliances and rewards possibly trade for other insider information going the other direction in the future. And the one thing is, folks usually trade on insider information more often to avoid losses than to achieve profits. Now, this may be because it's easier to detect trading on losses than on profits, since if everybody is getting big gains, they often don't look for scapegoats of people who got in just a little bit early. But now there is this idea that unclear insider trading laws are unfair, but the problem is if they're too clear, it leads to gaming the edges of the law, finding loopholes, while having a broader intent-based law discourages the bad intent and trying to game the system, since the intent is then what matters. Let's talk about one of the prototypes of the insider trading, Ivan Boesky. If you've seen the movie Wall Street, he was the model for the main character, Gordon Gekko. Ivan Boesky famously said, "I think greed is healthy," while the actor in the movie said, "Greed is good," but the sentiment was similar. Boesky made his money buying into companies that were likely to be involved in a hostile takeover where he could then benefit from the run-up of stocks. He developed a network of people with insider knowledge of likely mergers, especially Dennis Levine, who was at Drexel Burnham, which was one of the main companies working in junk bonds in the time. And in the spring of 1986, he paid Dennis Levine $2.4 million for information for some major takeovers. Levine was arrested that year and turned evidence against Boesky, while Boesky then turned evidence against a much broader network. Boesky ended up paying a fine of $50 million, but kept $50 million in other profits and walked away with $400 million from his whole range of other projects and acquisitions in earlier years that hadn't been prosecuted over. Congress would later pass a law allowing confiscation up to 6 times illegal profits from insider trading, but Boesky got out before that came into play. Another famous figure of the takeover and insider trading scandals of the mid to late 1980s was Michael Milliken. He was the main innovator of the so-called junk bonds, which were used to finance most takeovers and leveraged buyouts in the 1980s, and still matter to this day. The idea was he would make insider investments on trades for many of his clients. He would end up pleading guilty in 1990 to securities fraud, mail fraud, filing false tax returns. He had to pay $200 million criminal fine and $400 million in civil restitution. He ended up negotiating a 10-year prison term, but ended up serving only 2. The sentencing judge doubted the sentence was strong enough. As he said, far too many people would likely jump at the chance to walk away with hundreds of millions of dollars after serving 44 months in prison. The next headline scandal that took over the front pages, not just of the business press, was the Enron scandal of the late 1990s. At that time, when the company went bankrupt, Enron was the 7th largest company in the US, employing 20,000 people, and often hailed as the most innovative company in the country. The leaders, Ken Lay and Jeff Skilling, faced criminal charges for unloading their own stock while trying to persuade others to keep putting money in. They were charged with manipulating financial results, making false public statements, and enriching themselves with salary bonuses and grants of stock, even when they knew that it was not justified given what the performance that was happening in the company. Skilling was convicted on 19 counts of fraud, insider trading, and other offenses, and fined $40 million and got 24 years and 4 months in prison. Now, Skilling got off in a Supreme Court decision that said that the requirement of officers offering honest service was unconstitutionally vague, and his time was reduced on eliminating that charge. And we're going to come back to this honest service decision in a few weeks when we talk about general corruption. But this is the phenomenon we'll see in a number of places where laws are passed on the white-collar areas, and then the courts have often restricted and narrowed the punishments that can be applied. Associated with the Enron scandal was the scandal of Arthur Andersen, its auditor, which had largely covered up its crimes. Sharon Watkins would emerge afterwards as a figure who, within the firm, had called attention to the problems within the firm, and this raised the issue of how effective such internal whistleblowers can be. Watkins had been an auditor at Arthur Andersen, found the problems in Enron's financial reports, and tried to tell Kenneth Lay of the financial problems. She warned that the company will, quote, implode in a wave of accounting scandals. But Watkins didn't go public with her reservations, but only sought internal remedies. She even hoped the problems would go undiscovered by the public and the firm could just move forward. The problem with Arthur Andersen was it had been auditing Enron since 1985. The relationship was cozy. Arthur Andersen received $52 million a year in auditing and consulting fees, and didn't want to lose it by blowing the whistle on the firm. In the end, it was convicted for shredding documents to cover up its own auditing fraud. And the company itself was given a year's probation, almost unheard of at the time. And long before it came off probation, its clients had fled, and Arthur Andersen itself went bankrupt. In the wake of Enron, Arthur Andersen, and all of the other issues surrounding it, along with some similar problems, the Congress in the early 2000s passed the Sarbanes-Oxley Act, which sought to rein in accounting and other insider fraud. Sarbanes-Oxley, passed in 2002, had a number of provisions. Lots of requirements for officers to sign off on the books, the idea being to create at least one point of full accountability that the books were honest, the financials had been audited, and that somebody would attest to their accuracy. The sad point is 6 years later, we would have the massive financial crisis that would almost tank the economy, and Sarbanes-Oxley seemed to have done nothing to get in the way of that. But the law did require auditing firms not to also consult separate consulting activities for the firm itself unless the full board of directors approved that relationship. It required firms to rotate amongst different auditing terms over time, and required that all documents be retained for at least 5 years to avoid trying to cover it up and then claim, oh, we're just cleaning up. Created a new felony for destroying documents in order to obstruct investigations or to destroy audit records. And it created better protection for whistleblowers within firms to blow the whistle publicly, go to regulators. Finally, we're discussing a part of accountability for shareholder fraud that came through the plaintiff side, through lawsuits. Most symbolic of this was the story and saga of Milberg Weiss representing plaintiff lawsuits around the country. Much of the power of plaintiff lawsuits came from a 1966 change in the rules by the courts that made it easier to bring class action lawsuits, to bring together a wide disparity of plaintiffs with one lawyer to lower legal costs and have a much greater impact. Plaintiff firms like Milberg Weiss began challenging corporate insider fraud with plaintiff lawsuits representing defrauded investors. Weiss would describe their role. Because of the new rule, we had an economic incentive to represent a whole body of smaller victims who couldn't afford individually to bring these actions. At its peak, Milberg Weiss initiated more than half of all shareholder class actions nationwide, and 80% of those brought in California. Weiss, however, ended up being convicted of faking plaintiffs, essentially not having a plaintiff who necessarily was the one suffering harm, but was brought in just as a face of the lawsuit. In some ways, a technicality, but one that brought down Weiss and much of the action around shareholder lawsuits. Combined with the Supreme Court reversing itself in many ways and restricting class actions around the country, this significantly reduced investor lawsuits as a way to rein in shareholder fraud.